All persons having business before the Honorable Associate Judges, now presiding of the District of Columbia Court of Appeals, draw near and give your attention. God save the United States and this honorable court. This honorable court's now in session. Please come to order.
Good morning, everybody, and welcome to the District of Columbia Court of Appeals virtual edition. We have 3 cases on this morning's calendar, and the first one is Dominique Hawkins versus United States, number 19 CF 605. And just as a reminder, just so we can prevent background noise when you're not actually speaking or about to speak, if you could mute yourself, that would be helpful. Thank you. Ms. Pembroke, whenever you're ready.
Thank you, Your Honor. May it please the court. My name is Christine Pembroke. I'm counsel for Mr. Hawkins, the appellant in this matter. The issue before this court is whether the trial judge below erred in refusing to suppress evidence against Mr. Hawkins. On that issue, we maintain the evidence should have been suppressed because it flowed from a seizure of Mr. Hawkins that violated his Fourth Amendment rights, because the police did not have a reasonable articulable suspicion to stop him, and a reasonable person in Mr. Hawkins' position would not have felt free to leave. We also maintain that if this court were to find Mr. Hawkins was not seized in violation of his rights, the evidence should have been suppressed because it was the product of a illegal search. As to the first round,
excuse me, Ms. Pembroke, if we agree with you that it was an illegal search because of a lack of valid consent, do we need to reach the seizure issue?
well, the level of coerciveness that surrounded the search is a factor. So to the extent the court would feel that it had to address the coercive environment that Mr. Hawkins was in, it may also effectively decide the seizure issue. The two issues are very related.
You're speaking of facts. We can take those facts into account, can we not, without addressing the legal issue of whether there was an unlawful seizure?
I believe so, Your Honor. I think that's correct. You could conceivably do that, but I think it would be a bit of a dance to reach that conclusion.
I mean, I don't see why, and I'm wondering why you're fighting on that. If the government needs to make a showing that there was affirmative consent to do a search, regardless of what happened before, regardless of how coercive it was. And if we decide there was no consent given, why would it be hard to say we don't need to address whether or not he was seized beforehand? I mean, it's a close question. There's officers around, but nobody's drawn their gun on them. Nobody said stop. I don't see why you think that those two are so entangled. So maybe you could just spin that out a little bit more for me.
I mean, it depends on the analysis the court goes through. Clearly, the court could reach the determination that Mr. Hawkins' ambiguous body language of supposedly thrusting his torso towards the officers was not legally consent. I mean, assuming you even agree with the trial judge's finding on that, I'm not sure the video actually shows he did that. With his hands in the air was mere acquiescence, which the Supreme Court has said is legally not sufficient to show consent to a search.
For sure. I definitely understand the argument that, if he's been seized, maybe this consent is not freely given. But I understand you to be making not totally separate, but a fairly separate argument that regardless, seized or not, where's the consent? You are making that argument, right?
Yes, correct, Your Honor.
Okay.
Go ahead, Judge Deal.
No, I'm done.
Okay, Ms. Pembroke, could you talk to us about how, as an appellate court, we should be looking at the body worn camera, the video images here, when they seem to conflict with either testimony or findings?
That's a good question, Your Honor. I think that on appeal, the court does not have to give the same level of deference that it would to the trial court's findings when you have the video evidence there and you can actually observe what the video is showing you. I do believe that there's a tendency to give less and less deference to what the trial court was finding. In this particular instance, I think that the trial court neglected to mention a lot of facts in its findings that are apparent on the video. And JM says you have to consider all the facts in determining whether or not there's a seizure and remanded for consideration of the issue of whether the age of the defendant, he was a 14-year-old, should have been considered. So there's a lot going on in the, I'm sorry.
When you say less deference, you mean just a little bit of deference? Or I think we may have some cases, or I've seen cases saying, hey, we can look at this just as well as the trial judge can. And if a dispositive point comes down to what the trial judge is seeing on the video, we wouldn't give any deference. But you were speaking of it as if there's a sliding scale and we give less and less deference. Do you think, do you have any, I don't know if there's a case law on this, but how much deference do we give?
Well, I would think that if the video shows clearly facts that are contrary to what the trial judge found, you would not give any deference to what the trial judge found. And if the video is subject to multiple interpretations, there may be some deference that is owed. I do think it can be a bit of a sliding scale depending on the facts. This isn't an issue we briefed, but if it's something the court feels needs to be addressed in this case, I'd be happy to provide supplemental briefing on that.
Do you think this video is contrary to what the trial court found about the thrusting forward of the satchel as a sign of consent? Or does it just seem to fail to support or corroborate it?
I think that the video doesn't show my client thrusting the satchel forward to the police officer. I think what it shows is that the police officer was just reaching for the satchel. But it's possible that it could be interpreted differently.
Can you remind me, is there testimony? I remember Officer Denton's testimony was that he saw a nod and that was discredited by the trial court. But did he also offer this sort of thrusting type of justification for consent, or is that just from the video exclusively that the trial court viewed it?
Officer Denton was pretty insistent at the hearing that he saw a nod and that's what he relied on. I don't believe he provided any testimony about this supposed thrusting of Mr. Hawkins' abdomen in his direction as a reason for finding that there was consent to the search. That's something that the trial judge seems to have just found on his own from observing the video.
Now, we wouldn't need to address consent if we found that there was reasonable articulable suspicion for a pat down here. Is that right?
I'm sorry, I didn't understand your Honor's question.
If we find that there was reasonable articulable suspicion for a pat down here, we wouldn't even, it doesn't matter if there was consent or not, right?
That would be correct, but in this case, the trial judge found there wasn't a basis for conducting a pat down. So I think that that's a finding this court would have to defer to. That, implicit in that was the conclusion that the officers did not feel endangered by Mr. Hawkins.
But it's an objective inquiry, counsel. I mean, the government does press it on appeal, and whether or not the trial court said yay or nay, we can review that de novo, and they're raising it now.
Well, they would have to prove that the officers had a reason to believe that Mr. Hawkins was armed and dangerous. The reasonable articulable suspicion just goes to whether there's some criminal activity afoot. The basis for a pat down is whether or not he's armed and dangerous. And I don't think there's anything in this record that would support the belief that Mr. Hawkins was necessarily armed and dangerous.
I understand the distinction you're drawing, but let me just Am I mistaking the government to be arguing that there was reasonable articulable suspicion to believe he was armed and dangerous, sufficient for a pat down on appeal? I know that's not what the trial court found, but I thought the government was arguing it here. Yeah, they say reasonable articulable suspicion to frisk, not just to seize. So I think they're making the argument. I suppose I just want to hear what hear you articulate the contrary view.
Right. And I think we did address that point in the reply brief. In this particular case, Officer Denton testified that having a satchel isn't enough to warrant a suspicion about the person even having contraband. He alluded to the fact that he didn't know for sure whether or not Mr. Hawkins had other contraband in the satchel. It could have been a gun. And so for those reasons, we don't think that there was enough for the police to believe that he was armed and dangerous. But beyond that, he had his hands up in the air in a gesture of surrender. He wasn't like reaching for the satchel or doing anything that was threatening to the police officers with his body. So I don't think that I would agree with the trial judge here. There wasn't a basis to believe that Mr. Hawkins was armed and dangerous and that a pat down was necessary. I'd like to turn back to the initial issue that we think is before the court, and that is whether or not Mr. Hawkins was seized in violation of his Fourth Amendment rights. We think that this case is very close to Dozier in terms of the circumstances. There were a number of factors that the trial judge didn't even consider. He was an African-American male. He's being singled out by a convoy of 8 officers. I know the government says in their brief that the record didn't indicate whether or not Mr. Hawkins could see that the officers were armed, but the video shows that their weapons are very conspicuous. And he was hemmed in. There was no egress behind him. He's up against fencing and a building. And to his right and his left, there's walls and fencing and a building and buildings. And the only egress he might have had was being constricted by the police officers as they approached. So his egress was restricted. He obviously was so intimidated by the police officers, he raised his hands in a gesture of surrender. So we think the totality of the circumstances demonstrated that he was seized, and at that time, the police lacked a basis to believe that any criminal activity was afoot. They had no reports of any specific crime. Mr. Hawkins was—
Ms. Pembroke, let me ask you about what you call a gesture of surrender. If I were advising people on street law, I think I would say whenever a police officer approaches you, be sure to keep your hands in clear view so the officer does not get afraid. Why wasn't this just plain common sense rather than surrender?
Well, I think that if he had simply held his hands away from his body, as opposed to putting them up in the air, sort of assuming that, I'm surrendering to you, that might have been sufficient to address any safety concerns. But I would also argue that if just having the police in your presence is causing you to be so intimidated that you have to keep your hands away from your body around them, that simply lends to the fact of a seizure. And if that's the environment that we're living in, then armed police approaching you can amount to a seizure. That alone can do it. If that's.
Can I ask you a factual question about your comment about him being hemmed in and the means of egress? Is that just, I can't remember if is that supported by testimony or just by looking at the video? Because it does look like there's a fence, but it's hard to tell whether it's possible to leave that way.
I believe at one point, Officer Denton did say that Mr. Hawkins could have left, but if you look at the video, you can see that his egress is being constricted as the police officers cross the street. And by the time they've gotten over the sidewalk, there would be really no place for him to go because his passage is blocked to the right and left and behind. So it's primarily the video, I think, that demonstrates that he couldn't get around the police officers. So based on the totality of the circumstances, we would argue that Mr. Hawkins was seized and that the police lacked a reasonable articulable suspicion to do that. And for that reason, everything that flowed from that seizure. I'm sorry, Judge Fisher, did you have a question?
No, thank you.
Okay. Everything that flowed from that seizure should have been suppressed. But independently, if this court were to conclude that Mr. Hawkins was not seized, he certainly did not consent to the search of the satchel. And I think in this regard, the video is very compelling, because if you look at the video, and I tried to watch it really slowly, I wish I could slow it down even more, but at about 18 seconds into the video, Officer Denton is asking Mr. Hawkins, can I squeeze the satchel? And by 19 seconds into the video, his hand is actually on the satchel. So it was physically impossible for Mr. Hawkins to have relayed to the police one way or the other whether they could search that satchel. Officer Denton was touching it without giving him an opportunity to respond. Boston talks about the fact that, you know, the police can ask for consent to search, but they can't do it in a way that conveys that you have no choice about whether or not you're going to be searched. And that's exactly what happened here. Mr. Hawkins was not given an opportunity to say whether or not Officer Denton was going to squeeze that satchel. Officer Denton just simply did it. And the fact that he was asking while he was in the process of touching the satchel really doesn't undermine the fact that Mr. Hawkins hadn't consented to that search of the satchel. So for that reason, and you know, there were a number of other factors, his having his hands in the air, the fact that he didn't actually verbally say, yes, you can search this. The case law is clear, and I think it was Bustamante in which the Supreme Court said, you know, acquiescence isn't enough. Just acquiescing to a show of authority is not enough to demonstrate free and voluntary consent to a search. And that's exactly what happened here. Mr. Hawkins simply didn't say, no, you can't touch my satchel. No, you can't squeeze my satchel. But the fact that he didn't say that doesn't mean that his other actions were sufficient to support the conclusion that he freely and voluntarily consented to Officer Denton squeezing the satchel. So for those reasons, we would also argue that the evidence against Mr. Hawkins should have been suppressed, and without that evidence, he could not have been convicted.
Thank you, Ms. Pembroke. We will give you a couple minutes on rebuttal.
Thank you, Your Honor.
Sure. Ms. Gabriel, whenever you're ready.
You're on mute, Ms. Pembroke. Oh, sorry, Ms. Gabriel.
Oh,
Sorry about that.
Sorry, you're muted, Ms. Gabriel.
Okay, I think can you hear me now? Okay, good morning. May it please the court, Elizabeth Gabriel on behalf of the United States. There was no error in the trial court's conclusion here that appellant was not seized and that he in fact voluntarily gave consent to the search of his bag. I'll turn first to the seizure issue. This case is nothing like Dozier. In this case, Officer Denton approached appellant in daylight on an open driveway or sidewalk with other people around. There's no evidence that his path was blocked, as appellant suggests. At the beginning of the video, in fact, you can see Officer Denton turn to his left, and the body-worn camera shows an open sidewalk. Officer Denton didn't touch appellant, didn't withdraw his weapon in any way, and he addresses appellant with a conversational tone, a friendly tone. There was nothing in the circumstances here that even approximates the situation in Dozier or in Jones. Once, of course, Officer Denton then initiated the contact, he asked for appellant's permission to touch his bag, and appellant impliedly consented by moving his chest out, as the trial court found, moving the bag closer to the officer. And I do want to
Ms. Gabriel,
Yes.
Let me ask you about the implied consent. Is there any testimony to support the notion that Mr. Hawkins thrust the satchel forward, implying consent, or is that based solely upon the trial judge's watching of the videotape?
I believe it's based on the video. Officer Denton did not testify to a thrust of the chest in any way. But it's clear from Officer Denton's testimony that he believed that appellant's body language conveyed consent. And in fact, on the video, he says, he can be heard saying, "I appreciate that." And he said, "I appreciate that."
He nodded.
He based that on what he thought was a nod,
He perceived a nod,
which
yes.
the trial judge found did not take place.
That's correct. That the trial court found that there was not a nod, that wasn't visible in the video. But
So
I think
if the trial judge's finding of implied consent is based solely upon watching the video that we too can watch, how do we review her finding?
well, the finding is, it's a factual finding that has to be reviewed for clear error. This court is not a court of fact finding, it's a court of review. And unless there is evidence in the record based on the testimony or the video that demonstrates that the trial court's finding is demonstrably incorrect, this court must defer to it.
What does that mean to you when we're watching a video and she looks at a video and she says, "He thrusts his chest"? And I look at the video and I say, "I don't see any thrust of the chest." Does clear error mean, but maybe I'm wrong, so therefore I'll defer? Or like maybe my eyes are deceiving me? Or is it just, it's clear because we have a video in front of us that didn't happen?
Well, I think it has to be clear. It can't be, a possibility. It can't be, a question mark. It has to be clear from the record evidence. So if the court views the video as clearly not supporting the trial court's finding, then I would agree that deference would not be owed. But
there's a further legal question, which is, in what way does one sticking their chest out a bit when an officer is reaching for your bag, in what way is that impliedly consenting versus not putting up a struggle so you don't, provoke the officer? I guess I have a problem with putting the factual issue aside. The notion that somebody doing this as somebody's reaching for them, and I think you'll agree the officer is reaching as he asks, I have a hard time seeing how that's implied consent. So maybe you want to explain that.
Sure. Well, I mean, clearly this was a quickly unfolding situation, and the interaction was a fluid interaction that happened rather quickly. But in other cases, in Brown, for example, and other cases we cite in our brief, consent has been found where, based on nonverbal conduct, where a defendant, for example, hands something to an officer in response to a question. And we think that the appellant's conduct here in pushing his chest forward, pushing the bag forward, and you can see him sort of relax his shoulders afterwards, demonstrates that he was essentially moving the object closer to the officer in much the same way that in those other cases, the defendants gave their consent by sort of complying with the officer's instruction by presenting the object to be searched.
And counsel, I'm sorry.
It is unclear to me whether Hawkins was moving the satchel forward or whether the officer had quickly grabbed it and was pulling it toward himself so that he could squeeze it.
Well, I think that viewing the interaction as a whole, including what happened afterwards, supports the trial court's finding here that he in fact did present the bag for inspection. Once he does that, the officer says, "I appreciate that," and nothing in appellant's demeanor and his facial expressions or body language was contrary to that or suggested that the officer was incorrect or had misunderstood him. So we think that the way that the interaction unfolded supports the conclusion that in fact this was a consensual give and take, that appellant permitted the officer to touch the bag, and the officer understood that and correctly understood that based on appellant's conduct.
Ms.
Thank
Gabriel,
you.
The court, yes, sorry.
Judge Fisher, go ahead if you're on the same subject. I'm going to slightly deviate.
Do you think permitting the officer to touch the bag is the same thing as consenting to it?
I think so. If permission is voluntarily given, I don't see a distinction between that. I would distinguish that between mere submission, certainly, but I think that giving permission is giving consent. It's saying, okay, I agree to this.
But he didn't say, I agree to this. He just
Not in words.
He just refrained from slapping the officer's hand away. In that sense, he permitted it.
Well, we think there was more on the record. We think that the video does show him, presenting the bag for inspection, with his body language by pushing it forward. It's you could see in the video, he sort of, after he pushes his chest out, he sort of relaxes his shoulders back again, suggesting it was an outward movement towards the officer. And we do think it's significant that nothing in the remainder of the interaction suggests that Officer Denton got it wrong or misunderstood, or that appellant, felt that his will was overborne. But even if the court disagrees that there was consent here, we think that the frisk was supported by a reasonable articulable suspicion that appellant was armed.
Before you head that direction, can I ask you, is there any case law in our jurisdiction or maybe others to support in this particular context your comment about us needing to see clear error in the video if the video is all the trial judge is looking at, or that basically that I feel like I've seen cases that go the other way from that. But do you have any case law on that?
I don't have particular case law dealing with video evidence, but I think I don't see a reason to distinguish the video evidence from other evidence in the record in other cases. I mean, the video was part of the record here, which included the testimony of Officer Denton, which was generally credited. So I think the court has to view the evidence just as it would any other record evidence.
Although I imagine in trial courts, lawyers would argue otherwise and say, this is video, it doesn't lie. If it doesn't lie in the trial court, why does it possibly lie here?
Well, I think that the Court of Appeals has to adhere to the standard of review. The standard of review is clear, and that standard is clear error. So if the court views the evidence, the record evidence, and finds that the record clearly does not support the trial court's finding, then it is not owed. But if it's not clear, if there is some question about it, I think that the standard of review governs, and the court would need to defer. So I just don't see a reason to distinguish this from other types of evidence or other the way the court views evidence as established by its precedent.
Ms. Gabriel, let me ask you about what I construe as two searches. When the officer first squeezed the bag, it revealed to him that there was a gun inside, but he didn't tell Hawkins what he had discovered. A few seconds later, there's an opening of a compartment or a pocket in the pouch. If we think the squeezing was not justified by clear consent, can the second search survive, or is it tainted by the illegal squeezing of the bag?
I think the second search could not survive. I think that the squeezing of the bag would taint anything that came after it. So I think the court would need to find that there was consent for the squeezing. I can turn now to the question of reasonable articulable suspicion, which we think justified not just the stop, but the frisk of the bag as well. And so even if the court finds that consent was not voluntarily given here, the search would still be justified on the basis of reasonable suspicion. Here, the officer testified that immediately upon entering the block, appellant made eye contact with him, and immediately upon making eye contact, appellant then made a stuffing motion into the satchel, then grabbed his chair, looked at the officer again, looked left and right and behind him as though looking for an escape route. And that, of course, is in the context of what Officer Denton knew to be an area of increasing gun possession, arrests based on gun possession, and the association between satchels and firearms. In his testimony, he made clear that he was aware that satchels were being used that summer to conceal firearms. We think on the basis of all that evidence, the officer had at the very least a reasonable suspicion to stop and to frisk appellant.
Can I talk about the satchel for a second? Because I mean, he says, other than satchels, they're usually in waistbands. Do you conclude from that waistbands contribute to a reasonable articulable suspicion? This guy's
well, I think there's plenty of case law. I'm sorry, Your Honor?
This guy's got a waistband because he's got pants on, so he's probably got a gun.
Well, I think there is plenty of case law out there that supports the idea that a stuffing motion or furtive gestures into a waistband is suggested.
Yeah, I'm not asking about stuffing motions. I'm asking about this thread of argument that, you know, Officer Denton, who had been on the job for all of 4 months, had some experience of finding guns in satchels. And I'm sure he did. I'm sure, you know, guns are put in waistbands, they're put in bags, but people carry bags all the time. I could lift a satchel up from beside my desk right now if I wanted to. It's to say that we find guns in satchels, that sometimes guns are found in bags, to me does not give rise to an inference that bags heighten the suspicions. And I hear you arguing something different.
Well, I think that the testimony here was that bags of the sort that appellant had, that particular type of satchel, was associated.
What type of satchel? I mean, I actually don't see that testimony at all. So feel free to point me to where he says there's a particular type of satchel.
Sure. And courts.
I'm sorry, I don't mean to put you on the spot.
No, it's okay. I'm just looking
I'll review.
I believe that on the February 22nd transcript, the testimony from pages 20 or 21, 27, in that range, the officer describes the type of satchel, this bag that kind of sits cross-body or to the front of a person, and that this particular kind of satchel was the type of bag that officers were seeing that summer in those months of May to August as being used to conceal firearms. But
he had no frame of reference for prior summers. This was his first summer on the job. I mean, it wasn't like his first emerging trend. It's people have satchels. People who have guns with satchels might put their gun in the satchel. That's about as much as I can read into that testimony. And it's the notion that satchels are particularly prone to holding guns. I just don't see it in his testimony.
Your Honor, I think that the trial court certainly credited his testimony on that point, and found that it did support a reasonable articulable suspicion. So I think there was clear testimony that, in the time preceding the stop in this case, the officer had experience or had knowledge that satchels of this sort were being used to conceal firearms. And granted, he had started in the GRU in May of that summer, but he had been a police officer for many years. He testified that he was familiar with the way that the guns are concealed and held, and so he wasn't a newly minted officer in any way.
And one factual question, just 'cause I don't think we have the entire video in front of us. There are points where video that was shown to the trial court is referenced that we don't have, like before the officer gets out of the car. Apparently about 45 seconds of that was shown and we don't have it. There's also some reference. So I can see from the video that the man behind Mr. Hawkins is also being searched. There is a reference to one of the first two guys who they came upon was being searched, asked to lift his shirt and show his waistband. They were searching people regardless of satchel. I just wonder, I guess my question is there more video that was played for the trial court that we don't have? It seems like there is.
I'm not aware of any video that was presented to the court that we have not supplemented the record with. I think the video that we submitted was the video that the court observed. There was testimony.
Just to flag something for you in case you want to look later at the March 22nd transcript at page 39, they discuss the initial 45 seconds, and it sounds like they're showing it from the transcript. It doesn't show. Right. It's not like it shows anything particularly interesting. I think it sounds like it shows just the dashboard. But if there's more, and there is, I mean, I'd be interested in seeing.
Okay, I know that there was a portion at the very beginning of the video where there was no sound, and I think that was addressed at the hearing. Yeah. I'll check with trial assistant to see if there was something else presented.
Okay. Ms. Gabriel, on that point, do you think that can you see, or was it assumed you could see the stuffing action in the video? It's really, I feel like it's really, or is that part happen before, or does it happen while the video is on but it's too far away?
Right, and my understanding is that it happened before, that it's not captured on video.
Okay.
Ms. Gabriel, I have a request for you and Ms. Pembroke. Maybe you can cooperate on this. If I understand the record correctly, defense counsel Ms. Wicks entered into evidence screenshots, which in a sense froze the video. She maybe exaggerated, saying second by second. We don't seem to have those in the record, and I'm wondering if you can cooperate in providing those to us.
Certainly, Your Honor. I'll touch base with defense counsel and see if we can come up with those to submit to the court.
Thank you.
I see my time has expired. If there are no further questions, we would ask this court to affirm the judgment of the Superior Court. Thank you.
Thank you very much. Ms. Pembroke, we will give you about 3 minutes.
Thank you, Your Honor. While counsel was speaking, I was thinking about this issue of how to deal with the fact of the video. And I think that perhaps the case law that talks about what permissible inferences can be drawn from the facts might provide some guidance on that. So, for example, this court could credit the factual finding of the trial judge were there no video just based on the transcript, but what the permissible inferences that can be drawn from those facts is a question that this court really owes no deference to the trial judge. I don't know if there's any guidance in that case law that might be helpful in that sort of instance. We cited, for example, the case Anthony, in which the court talks about when there's ambiguous body language, the only permissible inference that can be drawn is that the target of the police did not consent to the search. You know, we talked about some of those cases in our reply brief and our initial brief, and I just mentioned that as perhaps an area that might bear fruit on this question. I also think that Judge Deal's questions about the satchel causing a basis for suspicion are very telling. At one point, Officer Denton in his testimony says, you know, just having a satchel isn't enough to justify a suspicion. And obviously, if criminals are carrying guns, they're going to concealed on them. They're going to be concealed in a backpack or in their waistband or in a bag. So the fact that criminals carry contraband in various items on their person does not mean that every person who carries a bag or a backpack or has a waistband on their pants.
But what
can
about, Ms. Gabriel mentioned the specific testimony about the crossbody bag being, something the officer had seen more frequently than other kind of bags.
So Officer Denton says he was basically involved in, I think, 6 arrests for gun possession. He doesn't talk about how many of those instances involved a satchel. I believe he was with the State Department for a number of years before he came back to the GRU unit. And he'd only been working for a couple of months. So, on its face, I think the testimony is insufficient to establish that this particular style of a bag was being used for carrying guns. He also is not specific in his testimony about when he apparently observed this trend. His testimony says, I've observed this trend to use satchels. But it's not clear if he's talking about the time period that transpired between when the incident occurred and trial, or prior to when the incident occurred, when he'd been only working for a couple of months and only made 6 arrests. So I just, on its face, the testimony was not sufficient to establish that there would be anything that would red flag a satchel. And I think the other problem with this analysis is that there's no indication of the weight of what was in the satchel, its contours, its firmness. So just simply carrying a satchel, as Officer Denton admits, would not be enough. And he does not go on to articulate what he thinks might have been in the satchel based on what he could observe. And if you look at the video, you can't really tell whether there's anything in the satchel. It looks like there's nothing in the satchel at all. So, there wasn't a basis for him to jump to the conclusion that the satchel necessarily had a gun in it. The fact that my client reached into the satchel as he was getting up is consistent with completely innocent conduct of someone who's in a high crime area and sees a number of police arriving on the scene and would want to get out of that area in case there was some kind of violent incident that was about to happen. And so they gather up their belongings and start to leave. He didn't flee. He walked towards the police in his hands in a gesture of surrender. And, even Denton says, if somebody's got their hands up in the air, I can't assume that they are agreeing to a search unless I get verbal consent from them. So I think the record is clear that the police did not have a reasonable articulable suspicion to believe that my client was armed and dangerous, and there wasn't a basis for conducting a pat down of him. Unless your honors have any other questions, I would urge that this court find that Mr. Hawkins was seized in violation of his Fourth Amendment rights, and his Fourth Amendment rights were violated when he was searched, and for those reasons, reverse his convictions.
Thank you very much. Thanks, Ms. Gabriel and Ms. Pembroke for your briefing in this case and for your arguments. The case will be submitted.
Thank you, your honors.
For your briefing in this case and for your argument. Everybody here? Okay, the second case on the calendar this morning is number 19 CV 861, Mobilize Green versus Community Foundation for the Capital Region.
Thank you, Your Honor. May it please the court? My name is Jeffrey Robinson, and I'm counsel for Appellant Mobilize Green. The question for this court is whether the court below erred in finding that there were no disputes of material fact precluding the grant of summary judgment in favor of the Community Foundation as to Mobilize Green's claims of breach of fiduciary duty and breach of contract. The answer to those questions is that the court below erred. In 2011, Mobilize Green was a newly formed organization dedicated to increasing diversity in the environmental movement and providing opportunities for diverse young people. That summer, Mobilize Green worked with the Forest Service and created a program that would further that mission. Because Mobilize Green was not yet a 501c3 organization, it went to the Community Foundation of the National Capital Area to act as its fiscal sponsor so that it could receive Forest Service funding for the program that it had developed. Mobilize Green brought that program and entrusted it to the Community Foundation. And the Community Foundation accepted that entrustment on a temporary basis, putting Mobilize Green's critical program under its control. The Community Foundation agreed to act as the fiscal sponsor for a limited period of time and to then transfer the funding to Mobilize Green or to a new fiscal sponsor to be arranged by Mobilize Green. The Community Foundation failed to transfer the funding to a new sponsor arranged by Mobilize Green.
Who was the new sponsor that Mobilize Green had arranged?
Is SSE, which was another nonprofit organization.
And what evidence is there that you had prompted, that your client had prompted the Community Foundation to make that transfer?
I believe that that in the record, there is evidence that Mobilize Green went to the Community Foundation, that the chairperson, the president of Mobilize Green, went to the Community Foundation and asked. And the court below went off not on the question of whether or not the Community Foundation had been asked to, but on the question of whose responsibility it was to actually obtain it, and holding that the contract was ambiguous on that regard.
Why
I'm
shouldn't?
not so sure it is ambiguous. I'm sorry, Judge Beckler.
No, you go ahead, Judge.
I mean, I'm not so sure it is ambiguous. It says quite clearly that Mobilize Green shall transfer the contract. What's ambiguous about that?
Well, I don't believe that there's two transfers at issue. And I just want to, there is the Community Foundation needs to transfer the fiscal sponsorship to a new fiscal sponsor or to Mobilize Green. And I think that's not ambiguous. But the court below found whose responsibility it was under that contract to go to the Forest Service for that was ambiguous. We don't believe so. We think that the structure and nature of the relationship made it clear that it was the Community Foundation's responsibility. But even if you credit what the court found and you go to extrinsic evidence, there's more than sufficient extrinsic evidence that the Community Foundation had the obligation, but the court below didn't.
Can I interrupt and just say, why shouldn't the transfer have been, assuming I'm talking about the right transfer here, have been Ms. Allen's responsibility? Because the Community Foundation makes, some fairly strong arguments that she was a sole negotiator with the Forest Service and so forth. Why isn't it clear that it was her issue?
Well, it's clear because, or it's clear that it is the Community Foundation's responsibility because they're the party at that point in the contractual relationship with the Forest Service.
I mean,
the whole reason.
I just want to understand your answer to Clause 8 again. Clause 8 that says Mobilize Green transfer to another fiscal sponsor. What's ambiguous about that?
I'm sorry.
I understand that the Community Foundation is part of the cost share agreement, so they're going to have to say, okay. They might have to sign some dotted line. But it seems like the onus under the contract is exclusively on Mobilize Green to make sure that transfer happens. And that's in fact what the founder does. She just waits till March to try to do it. So I'm confused about why that's ambiguous still.
Yeah, I think it's ambiguous because it says that we're talking about the transfer to the new fiscal sponsor, and the Mobilize Green does what it's supposed to do, which is it arranges for a new fiscal sponsor, and it goes to the Community Foundation, but the Community Foundation doesn't do that, arguably because the Community Foundation believes it can't do that without Forest Service permission. But the contractual relationship between the Forest Service is with the Community Foundation. And so the Community Foundation has to be the party that goes to the Forest Service to
Even
get
though
that
Mobilize
permission.
Green has no problem seeking that permission in March, they do reach out to the Forest Service and ask for it, right?
Right. They haven't. I suspect the question of no problem is one of the circumstances then pertaining. Having attempted to get the Community Foundation to fulfill its obligations and having failed in that and being in a fairly desperate circumstance because of the other failures of the Community Foundation, they go to the Forest Service trying to expedite or have obtained what they believe needs to happen. But the fact that they then subsequently go to do something isn't evidence of that it was their obligation to do so. But most importantly, and I think this argument makes the point, there are factual issues about how the conduct and what was going on goes to whose obligation it was. And what the court below failed, having found that the contract was ambiguous, it failed to examine those factual matters, but rather said, nah, there's no evidence about it from which one could find one way or the other. And I think it is clear in this record that there was evidence from, if you have an ambiguous contract, there is evidence from which one could conclude that it was the Community Foundation's obligation. And in that circumstance, it was error to not let the case proceed further for a fact finder to make those determinations.
Mr. Robinson, what you've been talking about seems to go to the claim of breach of contract. Why did any of this give rise to a fiduciary duty?
As the record will show, the contract was for a limited period of time, and that time period ended. And the breach of contract claim goes to whether or not it was the program was appropriately transferred. Thereafter, the program is still going forward, and the Community Foundation is engaged in sort of overseeing, holding on to the funding because the funding had been given to it, and overseeing what Mobilize Green was doing.
Let me ask you about the thereafter statement you made. The impression I have from your brief and from what you just said is that the fiduciary obligation arose not from the contract, but from the situation after the contract expired. Is that correct?
No, I think it's more complicated. It comes into effect in the period after the contract expired, but the process and the negotiation of the contract bears substantially on the existence of the fiduciary duty, because it's in that process that the Community Foundation understands the seriousness and the importance of it, and then accepts that it's going to take something on and continues to do so thereafter.
I rely on lots of people throughout an individual week. Some of them let me down. Does that mean that they have violated a fiduciary duty to me?
Unfortunately, Your Honor, it doesn't mean that all of them have violated the fiduciary duty to you. But when that person is sort of your banker and your overseer, and you're essentially you've substantially entrust responsibilities to them, and then they let you down, then that person has violated a fiduciary duty to you. So, of course, my relying on someone, my relying on the store clerk to give me the correct change doesn't create a fiduciary duty. But my going to someone and entrusting a substantial part of my assets and my program to them agreeing, yes, we're going to take care of this, we're going to do this, and then them failing does both give rise to the duty and to the breach.
Now, what if, so let's say that Mobilize Green comes to the foundation and, you know, we're relying on you, and the foundation says, whoa, don't do that. This is an arm's length transaction, and we're going to write this contract to say we don't have any obligation to you. The purpose of this contract is to benefit us, and that's the end of the story. And then the founder of Mobilize Green has testimony that says that contract, in fact, codifies the exact nature of our relationship. And this is not a hypothetical. This is how I read it. So what I see is a fiscal sponsorship agreement that says the foundation gets to manage the fund for its own purposes. It has no obligation to Mobilize Green. And then I have the Mobilize Green founder saying, yes, that is the extent of our relationship, exactly what's codified in the contract. That's at JA 121. So why isn't that dispositive on this question?
Your Honor, in this circumstance, I believe it's not dispositive because we keep going forward after the contract. And there is a relationship that exists and that goes forward with them post the contractual period, and which exists because the Community Foundation doesn't transfer the money. And so we're now in a world that is beyond the contract.
Sure, but I mean, so maybe there is a constructive amendment of the contract so that it extended past its ordinary expiration date. But why wouldn't the exact same contractual terms naturally govern the party's behavior after that date?
Your Honor, if the parties explicitly agreed and argued that that's what was going on, then that might be the case. But that's what's, and again, I don't want to be formalistic about it, but that's really what's at issue here, is that all of that evidence, that's not what happened below. It's not what the court found below at all. And because if the court had dug in to those precise kinds of, well, does the record show this? Does the record show that? How do they relate? It would have been completely obvious that there's a factual dispute about what is the nature of the relationship. In general, finding a fiduciary duty is a very factually intensive question in these circumstances. And that's an issue that goes to the trier of fact. Obviously, as counsel for Mobilize Green believes we win that. I'm sure that the Community Foundation would believe that it would win that. But that's a factual dispute to be determined by the fact finder, not a decision to be made by the trial court on a legal basis that is not sustainable.
I mean, it's a factual dispute for the fact finder if you've given enough evidence to get to a jury. And I guess my question is, where your founder says our relationship is governed by this contract, and the contract says the foundation gets to administer this fund for its own benefits, not for Mobilize Green. We can put aside the question of whether or not a 501c3 can have a fiduciary duty to you. What is the contrary evidence to what looks like an admission to me that the contract is what controls the relationship?
And again, Your Honor, because we're at one, most of the conduct that is breaching is in this sort of post-contractual period. And the question of whether they simply extended the contract or because the Community Foundation was holding on to the program that Mobilize Green created and continuing to work with it, created a fiduciary relationship between them is one for a trier.
What else could it do, counsel? I mean, you guys, if we take it, if I say that they're right, that it was Mobilize Green's obligation to transfer the fund, then what were they supposed to do other than, and you guys didn't do that, what were they supposed to do other than continue the course of conduct laid out in the contract? They could have just washed their hands, and then you'd really have a claim against them.
Well, but perhaps not, because if in fact it was their belief that we have a contract for a period of time and that the party, Mobilize Green, has failed to live up to its obligation to transfer, and that we don't want to have any responsibilities ongoing to Mobilize Green, they could have done what they ultimately did do without notice of Mobilize, which is turn the program back to the Forest Service.
I thought that happened at the expiration of the cost share agreement by operation.
I'm sorry, Your Honor.
You say they turned the contract back to
they turned funds,
expired, and that's when the Community Foundation got out of this business, right?
Yeah, towards the end. But if they believed that they were being
not toward the end, at the end, right? Am I getting a fact wrong?
Yes.
Okay.
Yeah, no, Your Honor is correct. But if the Community Foundation was of the view that the obligation that Mobilize Green was imposing upon it by not having fulfilled its contractual, the Community Foundation, as the party with the Forest Service, could have gone to the Forest Service and said, we agreed to do this for a period of time. We are now going to turn it back to you because Mobilize Green has failed. That's not what the Community Foundation did. Your Honor, I see my time has expired, and I'm happy to engage in further responses to questions, but.
If anyone else has any further inquiries, we will give you a few minutes on rebuttal, Mr. Robinson.
Thank you, Your Honor.
Whenever you're ready, Mr. Edwards.
May it please the court, my name is Matthew Edwards. I represent the appellee in this matter, the Community Foundation. Your Honors, good morning. I'll proceed in 3 steps this morning, Your Honor. I'll focus first and foremost on the fiduciary duty claim, followed by the breach of contract claim, and then I will briefly address Mobilize Green's lack of a viable theory of injury. Regarding the breach of fiduciary duty claim, the Superior Court correctly ruled that the parties in this case did not enter a fiduciary relationship. And the question before this court is actually much narrower than Mobilize Green's arguments would suggest. And the reasons are because of the explicitly undisputed facts in this case. My colleague argued that the relationship after the alleged termination of the agreement on November 11, in 2011, means that the relationship somehow was broader than the explicit terms of the agreement. But that's actually incorrect, and there's no support for that on the record for 2 reasons. Number 1 goes to a point that Judge Deal raised in the argument regarding a constructive amendment. And in support of that argument, you would also look at paragraph 7 of the contract, which explicitly states that the contract shall be amended to conform with any applicable provision of federal law. Now, of course, as the court's questions a moment ago indicated, the Community Foundation was stuck once the Forest Service declined to approve the transfer of the Forest Service agreement. So you could plausibly argue that the term of that contract was automatically extended to conform with the Anti-Assignment Act. But even putting that aside, there is absolutely no admissible evidence in this case to suggest the relationship was any broader between the parties after that supposed termination date. And of course, the reason goes to exactly the point that Judge Deal raised a couple of times. It is explicitly undisputed in this case, quote, whatever the relationship was supposed to be, it was in that document, close quote. That document referring, of course, to the fiscal sponsor agreement. The practical import of that is that Mobilize Green is unable to identify a genuine material fact arising from any circumstances outside of the plain text of the agreement. And so when you look at the plain text of the agreement, which controls, you see, of course, that the Community Foundation's undertaking in this case was far more limited than a fiduciary relationship would require. The very first page, the second paragraph, not the numbered paragraph, mind you, but the second textual paragraph, states that the Community Foundation was undertaking to operate a sponsored program fund, and that the Community Foundation would, quote, administer the fund upon the following terms, close quote. All of the numbered paragraphs thereafter are mere qualifications on the Community Foundation's administration of the fund. That means they never undertook to do anything like run the program, give good advice, give guidance, help ensure Mobilize Green's business success in any way, as is reflected not only in the plain text of the agreement, but also paragraph 50 of the undisputed facts.
There is a clause that says you will administer the fund. I forget the exact language, but I think it's something like upon the recommendation, as recommended by Mobilize Green or something like that. Is that ringing a bell?
Yes, Your Honor. You're referring to paragraph 5 of the agreement, which states that distributions from the fund shall be made upon recommendation of the organization, that's obviously Mobilize Green, as communicated by its authorized officer. So the most important word in that paragraph is the word recommendation, because for the reasons stated by the claims court in National Foundation versus United States, which is a seminal case in the nonprofit community regarding donor advised funds, a donor advised fund or a fiscal sponsorship can only recommend expenditures, but of course they can never command them because Section 501c3 requires the tax exempt entity to maintain exclusive use and possession, exclusive control over the funds within its control. And that's explicitly stated in the contract by virtue of paragraphs 3 and paragraph 7 of the agreement, which states the entire agreement is to be interpreted subject to the requirements of Section 501c3. And I don't believe there's any serious contention in this case that Mobilize Green could dictate payments in its own self-interest outside the boundaries provided by Section 501c3. So
Yeah, but I feel like that argument might prove a little bit too much, counsel. I mean, what would happen if there was a complete overlap of interest between the Community Foundation and Mobilize Green? They both have the exact same interests, but in the course of carrying out a contract, Community Foundation just blows off its own interest and starts siphoning funds. I mean, that would seem to be a breach of fiduciary duty to Mobilize Green, right?
no, Your Honor. In fact, that's the argument made by the plaintiff in the Nevius case cited in our brief. If you'll recall, in that case, which was dismissed on a 12b6 motion, which meant the plaintiff's allegations had to be assumed to be true, the missionary was arguing that she wanted to keep running her mission in Africa, whereas her sponsor in that case essentially took over her mission facility to turn it into a racially segregated bread and breakfast for apartheid Africa, and which would obviously be a violation of any charitable endeavor by any standard of the term. And the court held that notwithstanding those allegations, there was still no fiduciary duty owed to the sponsored individual, in that case, Mrs. Nevius, the missionary, because you cannot owe a fiduciary duty to the missionary itself. And that goes to the point we describe in our brief, that the missionary is not the mission. In fact, there's an important distinction between the parochial interests of a sponsored organization like Mobilize Green Incorporated and the sponsor's charitable mission. And just in case anybody thinks I'm slicing that onion a little too thin, I would urge the court to look at the theory of injury in this case. The project in this case concerned a $250,000 internship program that was supposed to last something like 6 weeks. The claim for damages is $3.3 million in lost business opportunities and net revenue, not even gross revenue. Profit left over after the interns have been paid for Mobilize Green in the future. Mobilize Green is not suing to compel a payment of any expense that allegedly was not paid during the project. In fact, it's explicitly undisputed that the Community Foundation made all of those payments, although there's an argument as to whether they were sufficient.
Well, their theory of damages was basically, we were an up-and-coming organization, due to your mismanagement, killed us. And I get that you think the record doesn't support this. They had a subsequent fiscal sponsor that seemed to have walked away from them from reasons totally apart from what they led to mismanagement. It seems to me a perfectly permissible theory of damages.
Well, it's a perfectly permissible theory of damages, Your Honor, but I'm trying to speak to the point you raised in your prior question regarding whether or not Mobilize Green's interests were the intended beneficiary of this relationship. And the answer to that question has to be no. Now, in the hypothetical posed by Your Honor, what happens if Mobilize Green was doing a perfectly good job running a truly charitable program? At most, you can say that in retrospect, Mobilize Green's interest and the Community Foundation's interest dovetailed. And in retrospect, Mobilize Green stood to benefit incidentally, which is a key adverb in the nonprofit world.
Am I right that your expert's proffered testimony said something like that? That's how these fiscal sponsorships work?
I'm sorry, Your Honor, you faded out for a second.
I'm sorry. You guys had proffered an expert. I believe you guys did, and Mobilize Green did not. And am I remembering the thrust of his testimony being something like, that's how fiscal sponsorships work, that they will be incidental beneficiaries but not direct fiduciaries? Or is there something in his testimony you want to point me to that spells that out? I mean, I have to admit, I find it a little bit confusing. This is not, I'm new to fiscal sponsorship, so if you could back that up with some evidence, I mean, I'm curious to hear it.
Yes, Your Honor. So you are correct. We offered an expert. Mobilize Green did not. Among other things, our expert described what fiscal sponsorship is and the duties of the standards of care that fiscal sponsors have to obey. That expert report is located in the joint appendix at page 767 through 792. And among other things, our expert described that yes, it is often the case. In fact, it is typically the case that people enter fiscal sponsorships precisely because everybody wants to do charitable work. And so everybody's interests are pointed in the same direction, but that's not to say that their interests are the same thing. And the reason that distinction matters is because that works really well for fiscal sponsors, is let everybody is going along. But as you saw from the private letter ruling cited by Mobilize Green's own brief, sometimes sponsored organizations go awry. And when fiscal sponsors have committed themselves somehow to operating for the benefit of their sponsored organizations, they find themselves in violation of Section 501c3. And in that opinion, in particular, the fiscal sponsor's tax-exempt status was revoked. That's all by way of saying that it is important to distinguish between the interests of a sponsored organization, like Mrs. Nevius, like the various missions identified in the revenue ruling cited in our brief, on the one hand, and on the other hand, the charitable mission of the company. And that's why it's important to keep in mind the theory of injury in this case. It's an appropriate theory of injury, but it just goes to tell you what theory of liability you're relying upon, because of course, your theory of injury has to bear some relationship to your theory of liability.
Mr. Edwards.
Mr. Edwards. Go ahead.
Go ahead, Judge
Fisher.
Beckwith.
Okay. Mr. Edwards, I just wondered when you were mentioning the 501c3 issue, what is your response to your opponent, Mobilize Green's citation of the IRS guidance provision that suggests 501c3 organizations can be fiscal sponsors and turn the contributions over to an entity like this, presumably, as long as they're ultimately operating in a certain way.
Well, I think as far as that goes, it's correct. And there's no dispute about that. And that's why I think the argument in Mobilize Green's brief is a little bit of a red herring. There's absolutely no dispute that tax-exempt organizations can sponsor non-exempt organizations like Mobilize Green. But to sponsor an organization is not to undertake to ensure their future success or to undertake to act in the sponsored organization's best interest. It's only permissible as long as that sponsorship is furthering the charitable organization's own charitable mission. And that's exactly why the agreement in this case says that the agreement is entered for the purpose of furthering the community foundation's own charitable mission. They should have cooperated. It was good to cooperate. You want more people out there doing charitable work, but at no point does that imply a fiduciary duty to act or give advice for the parochial interests of the sponsored organization.
Mr. Edwards, let me take you back a few minutes. You were talking about whether the two-page contract creates a fiduciary duty, and you rightly point out there's not much in there. But Mobilize Green, I think, is making a different argument, a big picture argument. At a minimum, this two-page contract established a fiscal sponsorship. And it is the very nature of a fiscal sponsorship that you have to do these various things. And so the contract implies a lot of duties that aren't apparent on the face of the contract.
So a couple of different responses to that, Your Honor. The first is that notwithstanding what somebody might read about fiscal sponsorship on the internet, the law governing fiscal sponsorship and the scope of an appropriate fiscal sponsorship is very clear. And that law is explicitly incorporated by paragraphs 3 and 7 of the fiscal sponsor agreement. That means that under the basic rules of contract interpretation, which say that you have to interpret provisions of an agreement to be consistent with one another, you can't interpret a fiscal sponsorship to imply duties that are so broad that they run afoul of the requirements of 501c3, which are explicitly incorporated in the contract. That's point number one. Point number two goes to the question Judge Deal asked me a few minutes ago regarding what fiscal sponsorship means. Now, of course, you can only oppose summary judgment on the basis of admissible evidence, and Mobilize Green has offered none. They can't offer unauthenticated hearsay printed from the internet to interpret what the phrase fiscal sponsorship means. So they can't raise a genuine dispute of fact in that regard. And they've offered no expert to explain what fiscal sponsorship means, which means they're not going to get it in that way. And that all goes to the more fundamental point governing fiduciary relationships generally, which says that an individual party's subjective understanding of what the relationship is not enough to create a fiduciary relationship. You have to look at what was actually done or actually said to undertake a duty to act for the benefit of the alleged beneficiary.
With what I've learned from studying this case, I think if I were about to enter into a fiscal sponsorship, there's no way I would sign a 2-page contract. If I were the sponsored organization, it'd probably be 50 to 100-page contract.
You know, perhaps, Your Honor, but I think in this case, less is more, because the point of paragraph 4 of the agreement, it says the purpose of this agreement is to further the interests of the community foundation, which is enough to say we're not undertaking to give you good advice. We're not undertaking to ensure your future business success. So I think that simplicity does have its benefits, and that's one reason why. Your Honor, I see I'm basically out of time. I would just mention on the contract claim that Mobilize Green has never discussed the contract and practicability doctrine, which was raised in our brief. I think that's the most path of least resistance for affirming the judge's ruling. And then as to the injury claim, our argument boils down to the fact that you can't have a claim for lost business interests or lost contracts if you can't identify any contracts that you actually lost allegedly as a result of the defendant's malfeasance. And on those arguments, Your Honor, if there are no further questions, I would ask this court to affirm Judge Kravitz's ruling.
Just one, what's the contract and practicability argument? What was impractical about the community foundation
So, Your Honor,
telling the Forest Service to go ahead and transfer this contract? I mean, why couldn't you have taken some steps to that?
oh, well, Your Honor, that goes to
Maybe, or just spell out the argument for me, because I'm afraid it's just not at the front of my mind.
That's quite all right, Your Honor. So as the the DC Circuit ruled in the Hester case cited in our brief, contract impracticability doctrine is implicated whenever the parties are supposed to achieve something, like in this case, the transfer of a fiscal sponsorship, but an intervening regulation or some other unexpected event makes that impossible. And in this case, there's no dispute that the Community Foundation agreed to transfer the agreement. There's no dispute that that the Forest Service was asked to bless the transfer. And there's also no dispute that the Forest Service declined to bless the transfer, which made transfer literally legally impossible under the Federal Anti-Assignment Act. And the point of the contract and practicability doctrine is that there's no argument that the Forest Service declined to do it, and there's no evidence to suggest that if the Community Foundation had been the one to proffer the questions, that the result would have been any different.
I see. Got it. Thank you.
Can I ask you one quick question too, Mr. Edwards? Who do you think the funds belong to once they were issued by the Forest
Community
Service?
Foundation, Your Honor. That's well established in nonprofit law. Whether it's donor advised fund or fiscal sponsorship, and that's the answer.
Okay. Anybody else? Thank you very much, Mr. Edwards. Mr. Robinson, we will give you 3 minutes or so, give or take.
Thank you, Your Honor. Just a couple of quick responses. One, with respect to the expert, we note that Mr. Edwards, the counsel for appellee, described the fact that there must be admissible evidence, and we would refer you to the brief, the fact that there is an expert report, but it has none of the indicia of being actually admissible evidence at the time of the summary judgment ruling. The thing that I would ask—
I don't understand. What's the problem? What was going to keep that expert report out? Was the expert unqualified? Well,
it was an affidavit. It was essentially a report, but there was no testimony or anything else with respect to the expert. There was no indicia of admissibility, sworn affidavit, or any of those kinds of the technical requirements. And I'm just responding that Mr. Edwards, having made a technical argument, that the court should take that into consideration. The most important thing I want to raise is that the arguments today point out that the court below did not get it right. The court below didn't rule on some of the bases that are being discussed here. It didn't go into the record and decide the matters that the questions that this court has raised. Rather, it ruled, and we think our brief shows clearly incorrectly, that the 501c3 regulations precluded the establishment of a fiduciary relationship. And it ruled that the contract was ambiguous and that there was no proffered extrinsic evidence that from which you could conclude that it was the obligation of the community foundation.
Yeah, I think I found there was extrinsic evidence that it was Mobilize Green's obligation, namely the March email.
I believe, no, I think the court found that Mobilize Green didn't come forward with extrinsic evidence, because if both had come forward with extrinsic evidence, then there would have been a dispute of fact, which would have to go to the trier of fact.
Yeah, but there was extrinsic evidence against you, is my only point.
But there was also, and the point that I think we're trying to make is that there was also extrinsic evidence in favor. That's the crux here.
What is that again? Just remind me.
I'm sorry.
What is that evidence again? Remind me.
I think, and in part, it was the nature and structure of the relationship. The fact that the community foundation had the contractual obligation, had the contractual relationship with the Forest Service would be enough to conclude that it was the obligation. If there was an ambiguity about whose responsibility it was, that would be reason to conclude, well, it was their responsibility because they're the party with the contractual relationship to move forward. That's, and I'm saying, that's the point. That we're at a point where the court below erred, and we're now coming up with arguments that the court below didn't address, didn't resolve, didn't dig into the record to try to find out with, to try to get to the result. And the Mobilized Green suggests that this court should return this matter to the court below and allow further proceedings consistent with the true summary judgment standard to proceed. Thank you, Your Honor.
Judge Beckwith, you're still muted.
Thank you. Thanks, Mr. Robinson and Mr. Edwards. We appreciate your arguments today and your briefing, and the case will be submitted.
Thank you, Your Honor.
Thank you, Your Honor.
From which
I think I found there was extrinsic evidence that it was Mobilize Green's obligation.
That's interesting.
found that Mobilize.
I think
Hello,
somebody's
counsel,
playing YouTube.
Yeah.
Then there would have been a dispute.
If either of you has any other devices on, or it sounds like it's better now. Can you both hear us?
I can hear you.
Okay, okay. The third case on this morning's calendar is number 19 CV 65, Bani Iqbal Prabak versus Barbara Suri et al.
Good morning, Your Honor. May it please the court, my name is Michael Smith and I represent the appellant, Ms. Prabak. I would like to reserve 3 minutes of my time. Procedurally wise, I'll just start from the first finding of fact and conclusion of law. And on April 23rd, 2014, the trial court, who was the finder of fact in this case, ruled on Ms. Surrey's claim against Ms. Stickleback. And the court, in its finding, states that this is a matter against Ms. Stickleback for 15% interest in a home in DC. And so she's seeking the courts to petition the property and satisfy her alleged 15% interest. The proceeds from which was the equivalent of about $90,000. And the court indicated that, of course, Ms. Surrey, who's the plaintiff, has the burden of proof. And the linchpin of her entire case in this testimony was from her friend and law school classmate, Evelyn Parchment. And the court found explicitly that in her own testimony, neither one had a word of credibility. Neither one can be credited in the least. And that's significant because the court ruled in that case in favor of the defendant and the appellant, Ms. Stickleback. Of course, the case was appealed and before a branch of this court, and this court remanded.
Mr. Smith, can I interrupt you? First of all, if I could ask Mr. Scott, if you could please mute yourself. We're getting some feedback. I'm not sure where it's coming from, but we'll try to eliminate all possibilities. But Mr. Smith, you're focused on the trial court's comments about the credibility of, I guess, Ms. Parchment and Ms. Surrey, but why is that still a live issue in light of how the findings went on remand?
It's a live issue because there were no additional testimony. No additional testimony were taken. The only thing that the trial court did was to review the finding of facts that from the trial, and it of course went through some briefs. But there were no additional testimony in any way other than the testimony from the first trial. And in that trial, the trial court held that neither one of these two witnesses were credible in any way and could not be believed.
So that's a very broad statement. I can well understand that the trial court might have, on reflection, said, that's way too broad. There are some things I can't believe, and maybe there's some things I can believe. And let me tell you what I find to be proven.
Well, but that's not what happened in this case. In this case, the very first factual finding, he said that neither one of these two can be believed in any way. This is not a situation where the trial court say, okay, I believe you on this point. However, on this point, I don't find you credible. It's not a situation.
Did he say neither one? Did he say neither one can be believed when ruling on remand?
No, it did not. He did not say that. But it's a situation where it's not. He did not have a second trial where he can say, okay, on the first trial, I didn't believe you because you testified to X, Y, and Z. On the second trial, I do believe you because your testimony is supported or I find you credible. This is one trial, and the Court of Appeals sent it back to say, address these issues. And so what he did was went back to the first trial transcript and say, all of a sudden, I now find you credible.
But why isn't that legitimate when, the findings he made the first time around, the Court of Appeals, was at a loss to understand exactly what they were based on and where they were coming from? Not necessarily that the result was wrong, but, what were they based on? And give us more details. So once the judge was, instructed to kind of focus on the issues, the more detail comes out. Why is it? I understand your point about the broad statements, but other than that, what's illegitimate about that process?
Well, it's unusual, it's fatal, because what the Court of Appeals says is, we're remanding for you to address these 5 specific issues. And it says, without limiting the trial court's obligation under Superior Court Rule CT Civ 52A, we ask that it makes finding of facts and conclusion of law regarding the following issue disputed by the parties. So if you have a situation where a finding of facts find that you are not credible in any way when you testify to say, I saw that gun, and the Court of Appeals remand that case and now say, okay, I find you credible that you saw that gun without taking any further evidence, that is not permissible, because this court has held that a trial court's finding may be set aside when the testimony adduced at trial does not meet the substantial evidence standard necessary to support the finding, and that's Biggs v. Stewart, cited in the brief. Here, the trial court found that neither one of these witnesses were credible in any way in its April 23rd, 2014 ruling. Nothing happened after that. These two witnesses were not rehabilitated in any way. The trial court simply went back and said, oh, I found you credible on A, B, C, and D without taking any further testimony. That is not permissible in any way. And while the question you're asking, Your Honor, why is it not allowed to go back and say A, B, C, and D? The finality of the testimony is there. Had he had a second hearing and say, okay, I now found you credible on A, B, C, and D, and address that in its findings and conclusion, that is permissible. But to say, I don't find you credible in any way on one day, and then use the same set of testimony and facts and to change the ruling, that is not permissible. And that's why this court had found that it should be set aside when it does not meet the substantial evidence. The trial court erred when it found in its finding of facts and supplemental finding of facts, conclusion of law, that Ms. Ickelback signed the POAs and the note authorizing Parchman to sell the property. Again, the trial court found that he, as the finder of facts, did not believe these two witnesses in any way during his April 23rd, 2014 finding of facts. There was no additional testimony. There were no additional testimony from Ms. Suri or Ms. Parchman or from any other witness. And so the only possible witness that the trial court could rely on in its supplemental finding of fact was the attorney, Mr. Nicholas, where he testified that, yes, he witnessed Ms. Ickelback sign the agreement. However, he testified during the trial that I saw her sign it, I believe she was competent. The case that we submitted clearly proved that he submitted a brief in the state of Maryland under oath saying, hey, I cannot understand my client. She has mental issues.
But haven't these issues already been decided in previous proceedings?
Well, they were. However, I'm raising the issue to say the only possible way that the trial court in its supplemental finding could prove that way was to rely on Mr. Nicholas' testimony. And so, because it's fatal that he relied on the very same witnesses that he found not credible in the first proceeding, I believe it's fatal in every aspect of his supplemental finding of facts, because when you do it's equivalent to appellee going forward without any witnesses at all.
Mr. Smith, I have a question about this effort to contradict or impeach the testimony of the attorney Nichols. Nicholas, is that his name?
Nicholas.
Yep. It seems to me we may be dealing with two different uses of the term competent. In a criminal case, competence can deal with insanity, criminal responsibility, or ability to understand the proceedings. Are we dealing with the same concept here when we wonder if she knew what she was doing when she signed a power of attorney?
Well, Your Honor, your question is well placed, and it would be, had been not for the fact that Mr. Nicholas in his motion to the court said, I have a problem understanding my client. He spelled it out. It's not a situation where you can say, okay, there are two standards. There's a criminal standards, does she understand all the proceedings? And in a civil context, where you can say, okay, she understands what's going on. I simply have to communicate to her to say X, Y, and Z. What he said to the court in Maryland is, I have a problem communicating with my client, and therefore, I believe that a competency hearing is necessary. Those are his words.
But this argument is different than the one you made a couple minutes ago. A couple of minutes ago, you said there was no substantial evidence because the court had discredited the witnesses. Here, there is substantial evidence. It may be outweighed or contradicted by different evidence, but you can't make the same argument here with respect to the power of attorney.
No, then I may have misspoken. What I've said is that Ms. Parchment and Ms. Surrey's testimony there's no substantial evidence. Those are found not credible. And
I understand.
I think I pivoted and say the only possible way that the court could support its argument is through Mr. Nicholas' argument. And I said that in his argument, there are issues with his argument because of what he filed in Maryland.
But my point is that saying there are issues with his testimony doesn't preclude the court from crediting his testimony.
I don't disagree with Your Honor with that. However, I think this court should look at whether or not the testimony deduced at trial meet the substantial evidence. What he said in his testimony is that he did not believe in any way that he believed that she signed a paper, she knew what she was signing. What he represented to the court in Maryland is that she is not competent, he cannot communicate with her. And so I'm asking the court to take judicial notice of what he filed in Maryland, not only on the oath, but as an officer.
Can you clarify among the different powers of attorney, the three different ones, which ones are you making a notary challenge to, and which ones are you making a competence challenge to?
I think the notary challenge is for the one that Ms. Parchment had documented to say that I have that gave her the ability to do transaction on behalf of the document.
We're having a little bit of trouble hearing you, and we can deal with it if this is the best we can get. But if you do have any other devices near you that are online that might be part of the issue.
I think that the issue with my other device is the background, Your Honor. I do have other device, but the background,
Okay.
We had some issues with that.
Okay, I didn't mean to interrupt. Go ahead.
Right. And so the issue with the notary was never really addressed by the trial court in its supplemental finding. Clearly, there's testimony that Derek, the notary, was not a notary in DC. He never addressed whether or not he was a notary in Maryland at all. And so the appellate put forth no argument to support that. And the trial court made no finding of facts that he was a notary, even in the state of Maryland.
But then isn't that the trial court did that because it said it didn't matter?
Right. But I think it has to matter when you're talking about a transaction and you have one witness that the trial court found that's not credible. So had the trial court found that Ms. Parchment was credible, then you can say, okay, it doesn't matter. But the trial court has ruled out Ms. Parchment altogether. and say, okay, I don't find you credible. So had it been notarized, then the trial court could have said, okay, fine, we have something to support this. We have the notary. So the fact that the notary is also absent, I think is fatal to that issue. To answer your question about the second issue, which power of attorney, Ms. Parchman, the second power of attorney is the transaction that allows the transaction between Ms. Ickelback and Ms. Surrey. However, even if you were to say, I believe Ms. Parchman's testimony, even if the trial court was to say, I changed my mind, I believe her testimony, Ms. Parchman said the agreement was not between Ms. Ickelback and Ms. Surrey, that she did not represent Ms. Ickelback in that transaction. There was no transaction between the two. The agreement, she believes, was to loan the money to Ms. Surrey to purchase 15% interest, and that was not a transaction between the two. That was a transaction between French and Surrey. I believe my next argument deals with the agreement that supposedly was between the two. As the court knows, that to have an agreement, that there has to be two parties. And so the trial court found that, yes, there was an agreement and that Mr. French was the beneficiary of that agreement. There's no evidence that supports that French and Ickelback entered into an agreement. And again, Ms. Parchman's testimony supports that there was no agreement between the two. And so the trial court granting of Mr. French's complaint or pleading on the complaint, I think it's fatal, because even assuming that the trial court is correct in saying, okay, we allow Mr. French to intervene into this action. Mr. French presented no witnesses. The same witnesses, Ms. Parchman and Ms. Surrey, would be the two witnesses that he adopted, and those two witnesses were found not credible by the trial court. And I don't believe that there's anything that happened after this court remanded the case to allow Mr. French to adopt. Basically, he adopted two void witnesses. And so there was no factual evidence for the court to grant Mr. French's motion, that even if he was to intervene, but to say, here is evidence why I believe that Mr. French is entitled to relief in the situation. I did argue the issue of statute of limitation. I adopt those arguments that I put forth in our brief. But as I indicated, there was no new evidence in the case. The only evidence relied on in granting French's complaint was the testimony of Parchman, which the trial court held that neither one can be credited in the lease. And that's page 55 of the appendix among other places. We are asking that the finding of facts in the supplemental finding of facts not be found credible, that there was no additional testimony, that there were no additional witnesses, and therefore the court should vacate the second, the supplemental finding of facts and uphold the original finding of facts, which was judgment in favor of
Mr. Smith,
yes.
we recently received a motion for leave to file an amicus brief on behalf of Mr. French. Have you had a chance to express your views about whether or not we should accept that amicus brief?
I received it on the 7th as well, Your Honor. I do not believe the court should accept that. This case has been going on since trial in this case was in 2004.
Are you content to make that statement, or do you want an opportunity to file something in writing?
I think I'm comfortable in making that statement. Not only has this court ruled on issues of intervention where this court held that it is usually an unusual situation where not only intervention is allowed after the court issues, the Court of Appeal issues its ruling. I don't think that there's any exception here that would allow this court to allow someone to intervene in a case or to file an amicus brief at the last minute in a case that has been around since 2014, has been up to this court twice. Not a situation where the amicus could say, I was not aware of this case, that I did not have counsel previously, or the statute of limitation has not ran. These are all issues that have been in this court has found on numerous occasions that, you know, after the appellate court has issued its opinion, it's very rare that it would allow intervention, because you start in the process, you're trying to process all over again. And to file an amicus brief days before oral argument and then expect counsel to address those issues.
Thank you.
Thank you, Mr. Smith, and we will give you a couple minutes on rebuttal. And if you would mute yourself while you're waiting. Thank you.
Will do.
Mr. Scott, we'll hear from you, and don't forget to unmute yourself.
Thank you, may it please the court. My name is Nigel Scott, and I represent the appellee Suri in this matter. As the court has noted and counsel has noted, this is a very old case. It has been to this court before and is back before this court for a second time. On the first occasion, it was before the court because of the court's ruling that on appeal was overturned, and the court was given wide latitude on remand to review the facts of the case and to present a new ruling on the matter. Findings of fact that the court acted on was based upon an agreement among all parties on remand that there was no need for a new hearing, that there was sufficient evidence in the record, and that if the parties were to submit findings of fact based upon their interpretation of the evidence, the court could rule on that basis.
Mr. Scott, I guess Mr. Smith's main argument seems to, involve or boil down to the kind of stark difference between the way the trial court was referring to the witnesses and their credibility pre-remand and post-remand. What is your response to that?
I think that's why the Court of Appeals, looking at the evidence, asked Judge Ross, who was the trial court, to review his evidence and to make findings of fact, because the findings of fact that he had made previously were not consistent with the record and an examination of the record. So that's why the Court of Appeals remanded the matter to him and asked him to review and deal with 5 specific issues that the court wanted to be enlightened on based upon the facts that he had before him. His way of dealing with it was to get findings of fact from the party and re-examine the evidence in light of the findings of fact submitted by the party. Appellant.
Just so I understand your argument, is it that, well, maybe he discredited those two witnesses the first time around, but on remand he reconsidered and he's welcome to do that? Or is your argument that upon the entire review of the record, he didn't need to rely on those two discredited witnesses in making these findings on remand? I think you're making the first argument. I'm just not sure.
I think it's a little bit of both, Your Honor. I think that when he looked at the record on remand, he found that the evidence in the record was contrary to his own findings, and that he may have misinterpreted some of the evidence that was before him. And in doing that, he decided that therefore he had to make new findings of fact or issue evidence or findings of fact based upon the evidence in line with what the Court of Appeals had specifically requested from him. 5 questions, and he dealt with all 5. He responded to each one and provided the reasons for his change because of what he found in re-examination of the record. And on re-examination of the record, he found that there was evidence to support a different finding from the one that he had made originally, which is fair and reasonable, given the fact that the Court of Appeals had asked that he look at it and make findings that were based clearly on what was in the record and not what was information that the court could not find support for. So the court was asking him to go back, review your record, and tell us what on re-examination, what your findings are with respect to 5 specific issues.
Mr. Scott, I have not found any portion of the record where Judge Ross said, "I'm sorry, I spoke too broadly. I didn't literally mean that nothing they said was believable. In fact, I am comfortable relying upon certain things, and let me clarify." Is there anything like that in the record?
I have not seen anything like that in the record. However, it is clear that he did a more comprehensive examination of the record the second time around and made findings of fact which he detailed and gave his reasons for. And unfortunately, in this appeal, appellant has not found it fit to address. They have found it fit to address only 2 of those findings that the court addressed on remand, asked to be addressed on remand. There were 5, but appellant only addressed 2. The other 3, therefore, it probably didn't feel the necessity to do it, although Judge Ross made specific findings on each of them. And so it's going back to the original record to ask the court to say to this court, there should be a trial, as he himself admits, this is an old case. Memories fade, events disappear, but the record and the findings of fact is there. And Judge Ross relied on that in order to make his findings of fact and to respond to what this court had asked him to respond to. So we believe that Judge Ross's action in this manner were clearly correct. There was no need to go back and hold a new hearing, particularly where none of the parties to the original trial was requesting that he do that. No one asked that he go back and take new evidence. Everyone agreed that it was appropriate on the record, at an open hearing, open court, that it was appropriate for him to get findings of fact from the parties, review those findings of fact in light of what the Court of Appeal was asking, and then make new findings of fact. And this is precisely what he did. There's no need for anything new. There's no need to look back and see whether Miss Parchment or Miss Suri was telling evidence is clear, because there was support for it otherwise in the record, which he found. That is, that the handwriting expert found that the powers of attorney were signed by Mr. Iqbal Kabak, that Mr. Iqbal Kabak had received the benefit from the transaction. And more importantly, with respect to a matter raised by appellant's counsel, the question of Mr. Nicholas, it is clear that the Court of Appeals in Maryland, on ruling on the motion, found that Ms. Iqbal Kabak was a manipulator. And so that whatever was raised with respect to her competency was dismissed out of hand because of the fact that she was considered to be a manipulator. And that is a matter that is uncontrovertible, that the court found, even after all that Mr. Nicholas may have said, or Mr. Nicholas may have asked, as a criminal defense attorney, to represent his client completely. The fact is that the court, in reviewing that evidence, found that Ms. Iqbal Kabak was the one who was trying to manipulate the court and manipulate the evidence. And so if we bring that forward to the questions before this court, and we look at the record, it is clear that Ms. Iqbal Kabak was incarcerated from 1988 to 2005. Between 1988 and 2005, she received the benefit of all of the actions that related to this property.
Wasn't it 1998, just to make sure, 1998?
Yes, she was incarcerated in 1998. And then she served a sentence and was released in 2005. Between 1998, for a 7-year period, she benefited from all of the transactions that were taking place. Once she got out of court, however, she repudiated all of that. And at that point in time, she wanted to start all over anew. But one thing that she cannot modify is the fact that when Suri got that 15% of her property, the property was valued at $600,000. 15% was the equivalent of $90,000. Today, that same property, after all of these years, is now worth more than $1.4 million. So Iqbal Kabak stands to gain substantially from her delay and dissembling if this court does not allow for Judge Ross's ruling to stand, property to be sold, and the funds provided to the party who really has suffered the loss here, which is French. French is the party that needs to be protected, and that is what Judge Ross decided to do, to ensure that French be made whole, and that is what his ruling would do. There is no need for this court to go back and try to retry this case when all of the evidence is in the record.
Mr. Scott, can I just ask you for a factual clarification? Is Mr. French, who's at issue, is this Mr. French who is mentioned in the amicus motion and brief, the relatively young man who's the ward. Is that the same person we've been talking about all along?
This is the same person, Your Honor.
Okay.
This is the same person. He suffered a neonatal injury, received an award, and it is the same person. He's now in 24-hour care. You know, completely disabled.
Okay, I thought I saw something in the record referring to an older person.
No, that's the same. That's the same individual, Your Honor.
Okay,
So I believe that Judge Ross's ruling on remand is appropriate. I believe that Judge Ross did take action consistent with what the court had asked and found that it was necessary to correct his own finding and to issue new findings which were supported by the evidence that was before him, based upon the submissions from the parties on the findings of facts in the record. So there is no need for this appeal would place this matter back to a point to 2000, going back to 2009, which is way beyond the time that anyone would be able to recreate the record and provide the trial court or this court with a satisfactory record to handle matters which are before it. So for the appellee, Your Honor, we are asking that Judge Ross's ruling be upheld and that the court rule in support of Judge Ross in this matter.
thank you, Mr. Scott. And Mr. Smith, we'll give you a couple minutes.
Thank you, Your Honor. Just to confirm, you can hear me?
Yeah, there's still the background, but we can hear you.
Okay. Your Honor, had this been a criminal case or jury trial where the jury, for example, for a hung jury, and the case is then retried, and the prosecutor and defense counsel enter into agreement to say all the evidence that's put forth in the first trial would be submitted to the court, and the court would make that determination, or the new jury would make that determination. Had the court in the first case struck and found not credible two of the fatal witnesses to the prosecution's case, the defense counsel would automatically win, because it's the same situation. You are putting forth a case with no witnesses.
But what about the handwriting expert? On the question of whether or not she signed the POAs, that's independent of the two witnesses that weren't credited. Why isn't the handwriting expert good evidence and enough to say that she signed them?
There's not a dispute. The handwriting expert can say, yes, this is her signature. Her state of mind is what's at issue here, where she's found not to understand what she signed. That's part of the critical assessment in the facts, where Ms. Parchman has testified and the judge say, I don't believe anything that you say. You are not a credible witness. So therefore, in his supplemental finding of facts, her testimony does not exist. And so to pivot on that, to answer Judge Ross' reexamination of the record, to say that, okay, the parties agreed that he does not need to take any further testimony, it simply means that the two witnesses that he found not credible does not exist. And that's not an agreement that the parties can say, we agree that you're finding of facts that you don't need to take further testimony. That's fine, but it's the judge's responsibility as the finder of facts then to go back and say, hey, I found that you weren't credible in the first place. I have changed my position because of X, Y, and Z. And Judge Fisher, you are correct. That is missing from the record. There's nothing in there that says, I now found, I re-examined your testimony, I re-examined the law. I made a mistake. Now I found you credible on this, this, and this, but I don't find you credible on this, this, and this. His statement, his blanket statement stands where he says, nothing that you say, I find nothing that either one of you say credible. The issue of Mr. French's judgment, I think that it's not of significant consequences whether or not there was a consent. This court has held that a judgment entered without the requisite proof is a judgment that is void. So if a judgment is void, it must be vacated. It is of no moment that appellant did not raise this claim in opposing the landlord's motion to reinstate the judgment or in moving to vacate the judgment, because a void judgment may be vacated at any time. And that's Wade versus Union Storage and Transfer. It's at 58 AD 493, 496 from 1948. Again, there was no new evidence for the trial court to, when it reviewed its supplemented finding of facts. It basically reviewed the finding of facts without any evidence at all, because it struck, in essence, Ms. Surrey and Ms. Parchman's testimony. And so to say, enter a judgment based on facts that struck, it's simply a situation where if it was a jury trial and the judge instruct the jury to say, do not credit these two witnesses' statement that was just made, and the juror went back there and deliberated and considered that evidence, and it was discovered, this court would say, no, that judgment, that verdict should be vacated because the jury disregard the judge's instruction to say, do not consider X, Y, and Z, and you considered X, Y, and Z, and therefore that is not a correct judgment and it should be vacated. And that's the situation in this case, where the judge struck the two witnesses' testimony, and then in a supplemental finding of fact, without saying, I'm clarifying this, I have now reviewed the testimony, I have now reviewed the facts, I've now reviewed the law as instructed by the Court of Appeals, and therefore I am making a finding that while I don't find them credible on this, I do find them credible on this issue, and this issue. That was not done in this case, and therefore the judge's supplemental finding of fact should be vacated, and the original finding of fact that's entered in 2014 should be affirmed.
Okay, thank you so much, Mr. Smith, and thank you, Mr. Scott, for your arguments today. The case will be submitted and we are adjourned.
This honorable court is now adjourned.